Good afternoon, everybody. So welcome to our presentation. My name is Jean Newlin, and I'm here to talk to you about Season 5 Outlander. That, I think, is the best thing to be talking about today, and I'm glad you could join my pod. I'm so sorry. You know how it goes during this time. We are all confused as to what day it is, and I should have remembered that today is Cinco de Mayo. So we are here today from Venable. Again, my name is Jean Newlin. I'm here with my colleagues, Sarah Call and AK Moody, and we're here to talk to you about estate planning. Because it's Cinco de Mayo, though, we thought, what a better way to look at this as a recipe. So as you see, our topic is turning limes into margaritas, based recipes for estate planning that you can do today. So we're here to talk to you about things you can do at home today, things you can do with discussing with others, including ourselves and other friends and family members, and just some overall things that are really important and helpful for today's world that we live in, both from the perspective of everyone being at home, but also from the perspective of we do have phenomenally low interest rates that we've never had. We have a lot of other circumstances that are unfortunate, but also may provide some planning opportunities. So our goal here today is to try to give you at least a little bit of something to take with you, maybe even a little bit of fun. I don't know, it's hard to be super fun with estate planning, but we'll do our best to try to make it a little bit fun, but also informative, to just try to do something different for the day and take our mind off of everything else that's going on in the world and just focus on something else that is part of our lives anyway, let's be honest. So what we're going to do here is we're going to talk about a basic few different things. So our agenda for the day is, number one, our basic recipes. So this will be discussion about what if I have no estate planning documents right now, what do I do? So we're starting from scratch and doing this all from the beginning. Or what if I have some estate planning documents, what should I be thinking about to update those estate planning documents? Our second sort of overall topic is what we call salting the rim, just as it sounds. These are some details and things that you should be thinking about. Particularly now is a good time if you have nothing better to do but look at your closet and say, I really should be cleaning that out, or I should be doing this. Is another opportunity to do something around the house and think about different things in your life that you might not have been thinking about, and have another to-do list item, but one that might be a little fun. And finally, we're going to talk about, our top shelf estate planning ideas for 2020, particularly, like I mentioned, this environment that we're in with low interest rates, also, unfortunately, some declining values, but that does provide some planning opportunities as well. So we will get started on our first topic, which is going to be our basic estate planning. What should you do for purposes of your estate planning documents? So as everybody knows, or maybe you don't know, we all have an estate plan, whether we like it or not. Our estate plan is intestacy. So if we have no documents whatsoever, the state laws do provide for us already. So you might say, well, then what is the problem? Why do I need to do any kind of planning? State's going to provide it for me, so I'll just hang back and let it all do whatever is going to happen. I don't need to worry about it. Well, let me tell you why you need to think about it. Number one, DC and Maryland do have lovely intestacy laws that say if you do not have an estate plan, here's what happens. You have a surviving spouse and a child in DC. Your spouse isn't getting 100%. Your spouse is getting 2/3. Your child is getting 1/3. So you say, well, what's the problem with that? Except for that could be a real problem if you were not anticipating a child inheriting a large amount of assets at the age of 18. Maryland has a similar system that there is still a split between spouse and children. So it is important to think about other states. Virginia is a little more generous, but at the same time, you still have to be very aware that intestacy is usually not going to be your best bet for accomplishing what you want to accomplish. It also loses some of the tax benefits. And later in the presentation, AK is going to go through what the current situation is in the tax law. And while we've had some very, very generous exemptions, both from the federal level and from the state level, it's still not the be-all, end-all from a tax planning perspective to just let assets pass 2/3, 1/3 to a spouse and to a child. That could create some tax liability that no one was ever anticipating. So again, it's very important to have this. The other items that are also important to note is there are assets that are not controlled by the intestacy laws, and those would be your life insurance, your retirement planning assets, and also anything held jointly. However, as we'll discuss a little bit later as well, your beneficiary designations don't just pop up by themselves. If they do, it's typically going to be your estate, which throws you right back into intestacy. If you have beneficiary designations, those are important to look at, because if there are some retirement plans, for example, may default to a spouse, may default to a child, or otherwise, but it's still important that you know what those defaults are and that you are being proactive in what you're doing. And with jointly owned property, if it is titled correctly, meaning that if an asset is titled as joint tenants with right of survivorship or with a spouse as tenants by the entirety, then operation of law will cause that asset automatically to go to the surviving spouse, which is very helpful. But at the same time, it may not exactly accomplish what you want to accomplish in the long term, and it's still important to look at. But it is nice to know that it's a simpler way to get through some of those issues on estate plan. So what do we need? What do we need to do if we are going to do an estate plan? So we're here to tell you it's not that complicated. Realistically, there's about 4 documents. And frankly, on the side, I'll tell you there's probably like 7, but we're going to pretend like there's really only 4 that are important because they're the ones that have the decisions in them. And those 4 documents are shown on the slide, which is a financial power of attorney, an advance directive for medical purposes, a will, and a revocable trust. And I'm just going to go over the first 2 just to talk about those briefly, and then we'll move on to the other 2. There's a lot more meat in there. In a financial power of attorney, it's important to have that document going back to the issue of your assets. What happens if you're incapacitated? What happens if you're out of town and you need to sign some documents? While the world has gotten much more simplistic in a lot of ways for signing documents through DocuSign, through a lot of other resources, it's still necessary for if you are incapacitated or otherwise need someone to sign for you, that you have a document to do that. The last thing you want is to go through guardianship proceedings and have a court overseeing your matters when everybody is getting along great and you just need someone to pay the bills. So a financial power of attorney is important. The word durable means it's effective immediately. You might go, I don't want that. I don't trust anybody in my family. So why would I possibly allow them to have any kind of access to my assets? There is a possibility that it can become effective when you are later incapacitated. But again, important to have it to avoid that court system. And then second, the advance directive, which is who's going to make medical decisions for you if you can't make them yourself, along with your wishes about what happens if you're on end of life scenarios. So those are important documents to have, and often can be very difficult because you have to make decisions about who's going to be the person to execute this for you in the long run. Spouse may be the first choice, but who's the second and who's the third if necessary? So those are important things to think about, big issues. But what we'd like to talk a little bit more in depth about are the will and the revocable trust, and what's the benefits and disadvantages of having those, or what's the good and the bad. So AK, I'm going to throw this over to you and have you go ahead and talk about those documents for us.
Thanks, Jean. Okay, so as Jean said, there are 4 basic documents, and the 2 that I'm going to cover are your will and your revocable trust. Now, a will in its simplest form is just a document that allows you to direct what happens to your assets upon your death. So forgetting the intestacy laws that your state is providing, it overrides those laws and allows you to determine how your assets are left. A lot of times we also create, in conjunction with a will, a living or a revocable trust document. And those 2 documents generally work in tandem together. Your revocable trust, though, is a vehicle that you can create during your lifetime. You typically are your own trustee. You are considered the settlor or the grantor of the trust as the person contributing your own assets, and you're typically the sole beneficiary of the trust while you're living. Now, any assets that you put into your revocable or your living trust during your lifetime typically avoid probate at your death, which is the same kind of probate avoidance idea that Jean was talking about earlier, with making sure your beneficiary designations are up to date and making sure that you have jointly titled assets that are either tenants in common or joint tenants with right of survivorship, where the title of the asset controls where the asset passes at your death and it doesn't have to go through probate. Now, if you don't do a revocable trust, or if you do a revocable trust but don't fund it fully and have assets that are not passing by operation of title or by beneficiary designation, then those assets go through your will. And even if you've been very diligent about retitling assets to trust and structuring them in a manner that avoids probate, everyone still needs to have a will, and that's for a number of reasons. First of all, there probably will be one or two assets that you've missed in the retitling process. It's not uncommon to see small checking accounts or bonds or cars, for that matter, that haven't been retitled to a revocable trust or in some other non-probate form. Additionally, a lot of people upon their passing will have other assets that come into their estate or issued in their own individual name. That those can be tax refunds or bonuses or final paychecks or things of that nature. So you want to make sure you have a will that's going to take those assets and direct where they go upon your death. Either the will itself directs that it goes outright to the individuals you select as your beneficiaries, or the will pour your assets over to your revocable trust and have that revocable trust document govern the disposition of all of your assets. Your will is also very important if you have minor children, because your will is the document that will appoint a guardian for your minor children. So even younger clients who think that they don't have a level of wealth that rises to the level of needing to do any estate planning or documents, you certainly need a will. And your will also will select your executor, or sometimes called your personal representative, the person who's in charge of administering your estate, and that will allow you to select the person who's in charge versus having state law select who that person will be for you. Now, with some exception, most assets passing under the control of your will have to go through the probate process. The probate process is the court supervision of administration of your assets upon your death. And the procedures for probate vary a lot by jurisdiction. So that's state to state, and even within the same states, between county to county, you may have some variances with how various courts treat the probate process. So in its basic form, to open your probate estate, your executor prepares the probate petition, they submit a copy of the death certificate and the original will, and they will submit that to the court, who will in turn accept the probate filings and will issue the executor or the personal representative with letters testamentary or letters of administration, which is the sheet of paper that gives your executor, the PR, the ability to transact on behalf of your estate. And that executor is going to take all of your individually titled assets, transfer them into your estate, pay any expenses or taxes or debts that are due, and then make the final distribution of assets out of your estate to the beneficiaries. Now, probate generally requires various filings that are due from time to time. There are inventories, there are accountings that are due, and probate is a public process. So all of these filings, including the attachments that accompany these filings, such as accounting or appraisals and things of that nature, are all public. And in some jurisdictions, the filings are also made available online to the public. So it is a very public process. There's typically a notification submitted in the local newspaper that alerts creditors and heirs at law that someone has died and that a probate estate has been opened. And so everything's out there. Now, probate also provides for typically a creditor period, where creditors have a certain period of time to come forward and file claims against the estate, where the executor can decide whether to disallow a claim, whether a claim is valid. But that creditor claim period and some of these filings we've discussed can also hold up and delay the ultimate distribution of the estate. Probate also requires costs. Typically, they're probate fees or filing fees that are going to be determined based on the size of the probate estate. So the value of the assets passing through probate. If you've done a really good job retitling assets into non-probate structures, but you may have missed an asset or two, then the probate costs are likely going to be small. So the idea is that probate is this process that these assets that are titled in a decedent's individual name will need to pass through before they can get to their ultimate distribution. Now I'm going to turn to the, let me flip the slide, turn to the costs and benefits of doing a revocable trust. So as we've just discussed the probate process, one benefit of the revocable trust is that the assets titled in the revocable trust during lifetime do avoid the probate process. Revocable trusts allow for there to be no automatic court supervision of the administration of your assets upon your death. If a trustee or a beneficiary needs to seek guidance from a court, they need to affirmatively petition the appropriate court to assume jurisdiction over the trust. The trust provisions of your revocable trust are confidential to the public, unlike the terms of your will, which is a public filing, and all of the probate filings. It may also be able to tailor the beneficiary's information rights depending on the state law that's governing the trust instrument and the language in the trust instrument. Now, another advantage of a revocable trust is it provides for disability planning. You establish your trust, you are your own trustee. However, you're going to name a successor trustee to start acting in the trustee role if you become incapacitated at a later date or upon your death. Now, this is used in conjunction with your durable financial power of attorney, where you're appointing an attorney in fact to act on your behalf. The successor trustee, though, will just be managing your trust assets. I think there is an important distinction, though, between the two, in that the trustee, whether it's you, the initial trustee, or your successor trustee, is the legal owner of those trust assets. And that's different than an incapacitated person who is the legal owner of their assets, but they're just delegating agency to their attorney, in fact, under the durable financial power of attorney. And sometimes that legal title distinction makes a difference when you're working with financial institutions to try to transfer the control of the assets over to the agent or the trustee. One last advantage of the revocable trust is it avoids what we call ancillary probate. If you have real property located in a state that is not the state where you're domiciled in, then if the real property is not titled in a way to avoid probate, your executor is going to have to open a second or an ancillary probate estate in that secondary jurisdiction. There are a few myths about revocable trusts that people believe that aren't necessarily true. One is that the revocable trust is not a tax planning tool. For income tax purposes, all of the income generated on your revocable trust assets will be taxed on your own 1040. It's considered what we call a grantor trust for income tax purposes. Additionally, because you're retaining the ability to revoke the trust, you have not made a completed transfer for gift and estate tax purposes. So all of the assets in your revocable trust will be included in your estate for determining whether or not estate tax is due at your death. Finally, revocable trusts also have expenses associated with getting them created, transferring assets in, and the upkeep of them. So depending on the state law, upon your death, you may have extra accountings that are due that wouldn't be due if you only had a probate estate. It would be a probate accounting and a revocable trust accounting. In addition, you're also going to have the assets that weren't retitled during lifetime ultimately retitled from yourself to your estate, to your revocable trust, and then to your beneficiary. So it adds in another layer of administration. So whether or not a revocable trust is the right fit or totally avoiding probate is the right fit is a case-by-case basis. And with that, I'm going to take my line and turn it over to Sarah to talk about salting the rim and things you can do at home.
Thanks, AK. So you've got your basic recipe, but those extra details like salting the rim can really make your margarita the best it can be. So the good news is that we have some things that you can do from home that you can use to make your estate planning recipe live up to its full potential. So let's start with having some conversations. Your heirs, your family should really know the answer to a lot of the questions on this slide. These are just some example questions, but they kind of break down into categories. There's the who questions, like who is your estate planning attorney? Who is your accountant? Who should I contact in case of an emergency? And then there are the where questions, like where do you keep your estate planning documents? Where do you have your insurance policies? Where is your safe deposit box if you have one? And then there are those wishes questions. What do you want to happen in the case of that you're on life support? Or what are your burial or cremation instructions? These can be very difficult questions and difficult conversations to have. And especially in a pandemic, of course, they're very difficult. A lot of us are on edge. Your family is probably very anxious. And, part of that anxiety can be about some uncertainty that we all have. And having these conversations, thinking about these questions can actually help us feel a little bit more like there is a plan and some certainty involved. So we would encourage you to press forward through some of those awkward conversations and think about those questions. Then the next thing to do is get organized. And by getting organized, it means having a central location for all of the information that your family might need in the case of your death or incapacity. And typically that is going to be a standard binder or a file in your office, someplace where everyone knows to look. But I would encourage you also to have a digital file as well. Of course, we're seeing, especially now, how useful it is to have access to documents online electronically. So, if you're working with us, then you have, we can help you get your documents electronically available to you and help set up a portal if you want to share certain things with your family. And then if you've gotten your documents updated recently, they probably include a section in your will that talks about what happens to access for digital assets and allows your personal representative to have some ability to access things online. But your personal representative can't really have all that information unless it's really organized. So that's where what you can do today can come in handy, where if you don't have a password manager like LastPass or 1Password, it's really something that you want to put on the top of your to-do list for estate planning and for just getting your passwords organized. It's basically a lockbox for all of your passwords that keeps them securely. And it's got a way to facilitate access to a trusted person that you name. If you go through and read in the settings about how to give that person access in the event of your death, then it's worthwhile to take a look at those settings and make sure that you've got that set up. If you have a family account where you share passwords with a spouse or someone else, then make sure that those sharing features work how you expect. So while you're at it, take a look at the secure notes section in those password managers, because that too can be a place where you can share information or keep information about your digital accounts available to both yourself and to others. For example, if you want to allow access to your devices, such as passwords that are to your laptop, if you want to include information about that, that's a place that you can store that information as long as your heirs know where to look for it. Things like getting your photos, your family photos and videos, if you want to figure out how to share those, that's another place to do that. There are going to be some accounts that you do want to deal with separately. Those are things like your Google, your Gmail, or your social media accounts like Facebook. They are going to have their own settings that you can go through and make sure that you have whatever your wishes are for those accounts after you're gone, that you've set up those accounts separately. So those are some things that you can do from home to make sure your digital life continues or doesn't, depending on what you want. So ideally, your family would have access to everything electronically, one way or another, whether it's through the electronic documents, through the portal, or through the password manager. And so then you can deal with the actual physical stuff around you. So this is an opportunity to spend some time looking at your things, your tangible personal property. That's things like your heirlooms, your art, your jewelry, anything that you can actually touch and it's in your home, are things that we don't necessarily have time to spend a lot of time in the office when you're with your attorney, but it has the ability really to make your kids fight after you're gone like nothing else. So it's a good idea to take some time now and think about your tangible personal property and work on that. A lot of cases, there's the first thing we really want to do is just make sure we keep track of the items. And when I say inventory, make an inventory, that doesn't have to be a list like you'd have as an accountant. It can be photos, it can be video, it can be any way that you can make a note of your important possessions and describe what they are so that we know the difference between, the gold necklace that your grandmother gave you versus the gold necklace that your aunt gave you, because those things really have both sentimental value and can have real dollar value. And there's some stories that are attached to a lot of those things too. So if you have some time now to record those stories and make sure that they are attached to those photos so that we know what the history of those objects are, that would be fun for your kids to know about as well. So you have your object, your description of the object, picture of the object, the story of the object. Also, if you've got receipts that you have, proof of ownership can be really important as well. So all of that stuff can be together, hopefully physically as well as in electronic copies. If there's any uncertainty about who owns the object, whether it's you or your spouse or both, or whether it's on loan or a gift from somebody or a loan to someone else, then talk to your attorney about making sure you have that documented properly so that there's no question and no fight after you're gone. Then when you've got your inventory organized, it's also an opportunity to share with your family, to invite them to talk about items that they might be interested in having after you're gone. This is a way to ask for their thoughts about your tangible personal property. Now, many estate plans include the idea of having a separate letter that deals just with tangible personal property. It's going to depend on your state and what you've got in your will, but sometimes your attorney will have suggested that you write a separate letter for dealing with your tangible property. And this is a good time, if you haven't already done that letter, to go ahead and do that now, something that you can do from home. Now, if you've got some particular valuables, things like an art collection, then that might require some additional thought and maybe some guidance from your attorney. So those things, if you've got an item that you're planning on giving to a museum, you probably want to give that some discussion with the museum to see if it makes sense for them to accept it in the way that you envision. If it's something that you want to sell instead, then of course you want to make sure that you have a plan in place that ensures that your kids get the full value of that collection. So whether that's having a separate person who's in charge of dealing with your property, with your art collection on your death, or whether you have some other plan in place, it's probably going to require some additional thought. But just the time right now is to make sure that you've gotten organized so that you have all of that information about your collection in one place, so that if it's insured, if you've got proof of title, all the people that you know of that would be helpful to contact. Having all that information will really help you get on the right foot for when you're talking to your attorney about those things. And the last thing I wanted to mention doing from home is something that AK and Jean talked about earlier, how asset titling can be so important for your estate plan and not just your documents. So going through and making sure that anything you expected to transfer to your revocable trust, that you have done that, and that everything, now is a good time to go to contact the insurance companies, the IRA providers, to see what the beneficiary designation has on record for them, for you. And then if you go through those and make sure that they are how you expected them, and you'll be in good shape for a conversation with your attorney if you need to update those. So I will go, while I am juicing this lime, I will make a note that we were going to have a PDF available for you to detail all of the things that you can potentially do while you are home. And with that, I'm going to take this lime juice and pass it on to AK.
Thanks, Sarah. Okay, now we're going to spend the second half of our program talking about some ideas for estate planning that are particularly attractive in light of low interest rates we have going on, and also just things to consider that you may haven't been doing in the past and may wish to engage in when, now's the time. So without further ado, I'm going to do a quick rundown on the estate and gift tax system and just numbers and exemptions and things to have in your head when you talk to your advisors about engaging in any lifetime transfers. So this first slide is talking about exemption and tax rates under the Tax Cuts and Jobs Act. You'll notice that there's an estate tax exemption and a gift tax exemption, and they both say $11.58 million. That's a little bit misleading, and that the estate and gift tax system is a unified credit system. So you have that $11.58 million to use an exemption during your lifetime with lifetime transfers, and any of it that you do not use during your lifetime is also available at your death. So the estate and the gift tax exemption are, in a sense, combined. Separately, there is a generation skipping transfer tax, or the GST tax, and it's put very simply, that is a tax that is due when you transfer property to someone who is 2 or more generations younger than you are. And you also have a separate $11.58 million exemption from the GST tax. So it's possible when you're structuring a transfer that it could use estate and gift tax exemption, but not GST exemption, and vice versa. All of these taxes, if they're due, are taxed at a rate of 40%. So prior to the Tax Cuts and Jobs Act, which came into effect, or the exemptions came into effect in the beginning of 2018, everyone had a $5 million exemption that was indexed for inflation. So the 2017 numbers for the exemption was $5.49 million. Beginning in 2018, the exemption increased to $10 million indexed for inflation, and you can see how the indexing has increased the exemption over the past 3 years. Now, as the Tax Cut and Jobs Act is written, there's a sunset provision for the exemption. So at the end of 2025, or January 1st, 2026, the exemption is going to decrease back to $5 million indexed for inflation. Now, this sunset provision is automatic, but it can either be extended by Congress, increased by Congress, or decreased by Congress, so that there could be congressional action that would decrease the exemption prior to 2025. For estate taxes, it's important to remember for U.S. citizens and U.S. domiciliaries that your estate, for estate tax purposes, is all of your worldwide assets. So if you have assets or real estate located in another country, that's still part of your estate for determining whether estate tax is due. Now, that $11.58 million exemption that I mentioned, that is also can be combined with a surviving spouse, the first spouse to die's remaining exemption if you're a married couple. So portability is a concept that has come into play in the last decade. Prior to that, there was a lot of efforts to equalize the spouse's estate so that you're maximizing each spouse's exemption. Now, with this portability concept, one spouse can die, leave his or her assets to the surviving spouse, which would be subject to a 100% marital deduction, and then that surviving spouse can file an estate tax return to take the first spouse to die's unused exemption and add it to his or her own. So that's a great planning tool that we now have. There's an unlimited marital deduction. There's an unlimited charitable deduction for the estate tax. And importantly, assets that are included in your estate for estate tax purposes receive an income tax basis step up equal to the fair market value of the asset on your date of death. Now, that's very important for structuring lifetime transfers, because if you gift a low basis asset, your donees receive your basis in the asset. It's called carryover basis. So there's no step up if you gift. So when you're determining what assets are appropriate to do gifting with, we like to look at assets that have higher basis and take the low basis and keep them in the estate until someone's death. For gift taxes, again, you have this $11.58 million lifetime exemption, but there are also some things you can do to take advantage of the gift tax rules. So there's a $15,000 annual exclusion per donee per person. Now, this is an exclusion. It does not use any of your exemptions. So you can gift $15,000 to each of your children, each of your children's spouses, each of your friends, and none of that uses your exemption. You can also take advantage of unlimited payments of medical expenses and tuition directly to the provider. Under the tax code, those are not considered gifts. And the gift tax also, in conjunction with the estate tax, recognizes an unlimited charitable deduction and unlimited marital deduction to spouses for U.S. citizens. Now, you also need to consider state estate taxes. There are various states that have estate tax, and we're very fortunate to practice in 2 of those states, Maryland and DC. So if your estate does owe state estate tax, you can take that estate tax paid as a deduction against your federal estate tax. It's not a credit, but you do get a deduction. Now, Maryland has a $5 million estate tax exemption per person, and that number is not indexed for inflation, but that exemption is portable to a surviving spouse. Your DC exemption for 2020, which does change each year, is $5,762,400. That exemption, however, is not portable to a surviving spouse. And Virginia's estate tax was repealed in 2007. Now, one thing that I had talked about earlier was avoiding ancillary probate if you've got real estate located in another state than the one you're domiciled in at death. That doesn't work for avoiding that other state's state estate tax if they have one. So you may want to talk with your advisors about seeing if you can structure your estate plan so that any out-of-state real estate is also not subject to that other state's estate tax. Now, that is the landscape of your estate and gift taxes. So with that, I will transfer it back over to Jean to start talking through some of the various lifetime transfers that you may consider. I think Jean may be a little frozen. Okay, Sarah, why don't you start talking about freezes and we can come back to Jean. Sarah, I think you may be muted.
Okay, so now I have a freeze planning slide to talk about planning for clients who have estate tax concerns. And again, clients who are in the millions, as AK mentioned. And we love estate planning freezes for clients who potentially have estate tax, because the idea is for each dollar that your estate increases, then potentially 40% of that increase, or 40 cents of that increase, is going to be going to estate tax, or even more with a state estate tax. So we've got, if we have a way to freeze that estate and keep it at the same level and transfer that appreciation to your kids, then that is a good move for estate tax savings. So we call that freeze planning, but for today only, we're going to call it estate planning on the rocks. So estate planning on the rocks works really well in low interest rate environments, and that's what we've got here. This AFR shown on the slide is the applicable federal rate, which is the rate that the IRS says you have to charge your kids when you make them a large loan of cash. You have to charge that interest rate if you want to avoid making a gift. Now that interest rate is so low, it's basically below 1%, that freeze transactions work really well. It's good news if you've got loans that you want to make, of course, but it's also really good news if you have a loan that's already outstanding and you want to refinance that and get it back into a low interest rate. And I've got on this slide some things that you might want to think about if you're doing some refinancing for a lower interest rate, basically trying to respect that loan as a true loan instead of a gift, and thoughtfully refinancing it. But ultimately, it's going to be a good idea to get that lower interest rate, especially if you have a very old loan with a high interest rate, or you are planning on extending that loan anyway. There's a couple of slides here. I won't go through them in detail, just because it's out of really the scope of the presentation to talk about, but just wanted to give you a couple examples of estate planning on the rocks. The main two that we see most often are grantor retained annuity trust, or GRAT, and that in particular, it works well when interest rates are low and values are low, which of course is particularly true for a lot of the volatility in the stock market. It works really well for those types of assets. And then the second one that we see often is a sale, an installment sale, where the client sells the asset, the appreciating asset, to a trust for kids in exchange for a promissory note at that low AFR rate. And that, again, freezes the value and allows the assets to grow in the children's estate. It's structured as a transaction that's not subject to income tax, so that's why it has to be this particular type of transaction. But wanted to give you some examples of things that you might hear with your attorney if you're in that category. We're happy to talk through more of those details with you. I think Jean is back available. So Jean, I will go ahead and shift it back to you in earlier slide.
Sorry about that. Venable VPN works great, let me tell you. It's been a day, right? I'm going to move back to our slides if I can do this. One more. All right. So, sorry about that. This is our world of technology, trying to work from home, right? So sometimes it works and sometimes it doesn't, but here we are. So hopefully this will stay on for another couple minutes. All right, so let's talk about what you can do based on the exemptions, what is out there as options on the simple side, and obviously, as Sarah was talking, on a little more complex side. So from the perspective of going back to what our exemptions are, easy are cash gifts of the $15,000, and a married couple can do up to $30,000. That's an easy one. It doesn't have to necessarily be cash, but it can be cash. But that's one that is very simple, although you might go, well, why in the world would I ever hand over $15,000 in cash to anyone? That would just be insane. But there are other things that you can do to utilize that annual exclusion from a variety of other ways to do estate planning. One of which is a 529 plan. Now, you might say today, and if you look back to 2008 and 2009, when the market went down, a lot of people were in a position where they set up 529 college savings plans for family members, and ended up the kid was getting ready to go to college and the plan had just declined in value substantially. So there are risks associated with these plans, but there are benefits to these type of plans. And two of the benefits are, number one, is that it is a tax-free way to grow assets for the benefit of a family member, usually a child or a grandchild, to help pay for college expenses. And what's also nice about that is it goes beyond college expenses. It goes to grad school. I've heard people talk about golf school and cooking school. So you want to set one up for yourself and get some tax-free growth. Now might be the time to do that, to try to fund a future plan for schooling. But it is a way to get some tax-free growth. And when the assets come out to pay for the school, you are not in a position of paying tax on it, which is great. The other benefit of the 529 plan is they permit you to front load the 529 plan with your annual exclusion. So you get to front load it with 5 years worth of annual exclusion right in the very first year. So that's a way to get some real assets into the plan, get some real growth going, particularly if it's for a very young beneficiary. And the other benefit is it's not includable in your estate and you still kind of manage the assets. There are some limitations on how they're managed, but it is an option. An alternative to the college saving plan is some states have prepaid tuition plans, which will be very interesting in the world we live in now, and this online schooling and how things may change on what cost is for tuition. But there are some still, they're out there, and it does basically lock in today's rates for some future time at which the person would go to college. Virginia has a very significant one of those. If you don't go to school in Virginia, the money can be applied to another school in another state, just literally applied. You don't get the tuition benefit like at Harvard or something. And as AK mentioned in the earlier slides, you can always pay tuition and medical expenses directly to the provider on behalf of another person, and that's very helpful. And also, as AK alluded to as well and spoke of, is this carryover basis concept. So if you're saying, well, I really don't want to gift cash because cash technically doesn't have a basis, in that sense, it is what it is. And you say, well, I'd really like to give this stock in this sort of up and coming company and I really have no basis in it. You do have to think about, well, when you hand it over to a child, a trust, or wherever it's going, they are going to be responsible for the income taxes on the gain because there will be no adjustment on that. And you have to think about, is that good or bad? Income tax rates are technically lower than estate tax rates. Estate tax rate at 40%. Income tax capital gains rates are much lower than that. But you have to think about where you live too, and whether how much lower will be on that person and their tax rates. So another important change, I want to say, or something maybe not a change, but what's going on in 2020 that's something you should think about is the CARES Act that was passed has done a lot of different things for purposes of retirement account planning and things you can be thinking about doing today with respect to your retirement accounts, particularly regular IRAs, but any type of plan. Number one is you are not required to take a minimum distribution if you're already in the world of minimum distributions. So if you're thinking that it would be better to defer your income tax consequences until a future year, you have that ability to do so in 2020 and not take that minimum distribution. You might think the opposite and say, well, my income is likely to be down this year, so I might want to go ahead and take it. So just something to think about on that one. Also, when you're thinking about your income taxes for 2020, it might be a good idea to convert regular IRAs into Roths, which will cause an immediate income tax consequence payable next year, but it's something to think about as to whether this year, given the circumstances, might be a good year to do that conversion. So in the future, when the money comes out of the Roth, you're not in a position of paying income taxes. So what that leads to, though, is another change that we probably haven't been focusing on, which is something called the Secure Act that was passed at the end of last year and basically did us a major disservice for IRAs and retirement plans, which is basically eliminating the lifetime stretch of IRA and all different retirement plan benefits for a beneficiary other than a spouse. There are some other exceptions. We don't have time to get into all the exceptions, but effectively, anyone other than a spouse has to withdraw everything from the retirement plan by the end of 10 years following the participant's death. Now, they don't have to do it on a year-by-year basis. They can wait till year 10, but they do have to do some planning for it. And what's important is we talk a lot in our planning about trusts, And there's a big question mark of whether trusts are really a good idea or not, because you might end up cutting that back to 5 years if you're not careful in how the planning is doing. So again, going back to what you should be looking at is beneficiary designations. Have you thought about doing trust? Do you have trust in there? Should those be revised given these new rules? So just something to remember that maybe we kind of lost a little bit of focus on. And then the last item I just want to touch on is life insurance. We talked about looking at your beneficiary designations and what you have, but remember, life insurance, a lot of people have a significant amount of life insurance, either through an employer, through other policies they've acquired. And that life insurance is part of your estate for estate tax purposes, even though you can't touch it. So you get no benefit of it until you're dead, and you get no benefit because you're dead. So if you have a $5 million life insurance policy, that's great, and it goes to your spouse. But if your spouse doesn't survive you, that's $5 million more of assets in your estate that may be subject to estate tax, depending on the estate tax exemption and your other assets. So this is a good time to think about, what life insurance you have. Do you need more life insurance? And whether that life insurance should be held by an irrevocable trust. If it's in the irrevocable trust, and if certain rules are met, for example, if you've transferred it, you have to survive 3 years to keep it out of your estate. But if that's the case, that asset, that life insurance, will not be counted as one of your assets if it's in this irrevocable trust. So it's a great way to protect it from the estate tax. It also has some creditor protection benefits. And the biggest thing that I think we see a lot of is the issue of liquidity. Do I have enough money to pay those estate taxes? What if my estate is a bunch of real estate and I've got like some cash, but I put it all back in the real estate? Life insurance is a great way to deal with that liquidity issue, particularly using the irrevocable trust. And one thing I've been hearing a lot about is today's world. If you're looking to get a new life insurance policy, things are changing fast. And I'm sure that most policies have never contemplated if you die during a pandemic as part of payout. But it's very possible that insurance companies are going to start putting that in, that is an exception to when you would be paid. There's other things with the low interest rates are not necessarily favorable to life insurance premiums. They could go up substantially. So if you had all been thinking about life insurance or looking at your current life insurance, now is the time to do it and think about, should you be replacing policies? Should you be getting new life insurance? How is your liquidity? How should that life insurance be held? Should it be in an irrevocable trust? What is your situation? And now is a really, really good time to think about that. So that is all me, and I have no idea where y'all left off other than when I saw you on the other slide. So I will pass it over. I think if Sarah, I don't know if you're completed with yours or if we're going to Charitable. So
I'm going to wrap this up with a very brief discussion on charitable giving. So, and I've skipped forward to slide 29. So as we've talked about, there is an unlimited charitable deduction for the gift and estate tax. Most of you also know that there's also a deduction available for income tax for charitable contributions. So when you're thinking about giving assets to charity during your lifetime, one thing to consider is the basis of the asset. So if you have low basis stock versus cash, we certainly recommend thinking about giving that low basis stock to the charity, because they're not going to have to recognize any income on the gain, and you're holding on to the cash. The charitable deduction you get for income tax purposes is going to be based on the fair market value of the date of the contribution. So you get the contribution based on the appreciated value of that appreciated asset. Now, when gifting or when leaving assets to charity upon your death, we like to talk about tax-deferred retirement plans as being a great asset to leave the charity. Why? Because your non-charitable beneficiaries are going to inherit those retirement plans and have to pay the income tax on those assets. And under the Secure Act, most heirs are going to have to pay that income tax within 10 years of inheriting the property. If you instead leave that tax-deferred retirement plan to a charity, that charity can take the asset, they don't have to pay any more tax on it, and it leaves your other assets that don't have any built-in income issues to your non-charitable beneficiaries. Now, With the CARES Act that was enacted due to COVID-19, there's some additional charitable advantages you can take advantage of. So in most years, there is an AGI limitation of 60% of your adjusted gross income. It's available for deductions for cash contributions to public charities. Under the CARES Act, this limitation has been lifted for the year 2020. So you can give more than 60% of your AGI and take that deduction. Now, this does not apply to contributions of assets that are other than cash, and it also doesn't apply to contributions to private foundations or donor-advised funds or other non-public charities. And those limitations for those types of contributions still apply as in prior years. The CARES Act also provides an additional $300 above-the-line deduction for taxpayers who do not itemize deductions. And finally, I'll touch very briefly on tax planning with charitable giving. We typically see two types of trust, a charitable remainder trust and a charitable lead trust. Charitable remainder trusts are trusts that are created for a term where the present beneficiaries, or those receiving distributions during the trust term, are the non-charitable beneficiaries, and the remainder of the trust at the end of the trust term goes to the charity. In today's low interest rate market, we're seeing maybe a better idea is to use a charitable lead structure. And that's very similar to the GRAT that Sarah was talking about earlier. It's a trust set up for a term of years. You, the grantor, make a contribution to it. And instead of, like in the GRAT scenario, where you, the grantor, receiving the annuity payments each year, instead in the charitable lead trust, the charity is receiving annuity or unitrust payments each year. And anything remaining, any assets remaining in the trust at the end of the charitable lead term, when the trust terminates, go to your remainder beneficiaries. This structure uses the Section 7520 rate. So because it is currently very low, it's very good strategy to bet that if you put assets in a charitable leads trust, the remainder going to your beneficiaries will beat the 7520 rate, and you'll be able to make a exemption and tax-free transfer to your remainder beneficiaries without using any of your gift tax exemption. So with that, I will turn it back over to Jean with the Sarah's juice and some salt to finish our recipe and take us home.
I now have the margarita ready. I really just decided I would just drop off and make margaritas, which is actually lemonade because it's too early to drink. But that's okay, or it depends on where you are or who you are, I guess. You can say whatever you want about drinking. But we wanted to have at least something, fun to go from here. I think, the most important thing I think out of all of this is obviously we have dumped a humongous amount of information on y'all to think about, for you to pass along to your friends, your clients, yourself, your children, whomever. But I think that one of the things we always tell all of our clients is, regardless of the situation that we're in today, it is always a good time to do some checks on your estate plan. And this might be one of the maybe better times to do it. I know we're all stretched very thin and have a lot going on, but it's also an opportunity to sort of get things in order. And as Sarah pointed out, it's a way to take a little bit of control back to yourself. So I think, just something you can say, oh, I've gotten it. I mean, I had someone actually email me and said, thank you. I can sleep well at night because my plan is in place. And that was really, rewarding to hear, and nice that we can actually help people do that, and that their financial advisor and CPA are part of that and can help them do that and feel a little bit more secure at night with respect to all of what's going on. So I think that's important. Focusing on gifting and these various techniques that we have today are important as well. Some of them are very easy to do. We tried to focus on the less complex, and not go into super duper. You've heard terms of like BDITs and BDOTs and like all these fun terms. We're not looking at that. Not that those are not opportunities, and there's other things out there that are opportunities, but we're trying here to really focus on things that we think are somewhat easy to do, that do help a lot with an estate plan, and take advantage of, these low interest rates and situation that we have going on here. And the one thing that I will mention that, is important to think about you say, well, how am I going to sign these documents? I can't get together with people, or I'm worried about doing things. We have a situation where the states around here are all different, as not surprising, on how you can do remote signings or electronic signings or this or that. But nevertheless, I think that everyone has, in light of those and in spite of those, come up with some creative ways to get some things done so that each person can have peace of mind of what they're doing. Even if it's an interim measure, there's certainly ways to deal with getting things kind of in place. And hopefully that won't be necessary soon. At least maybe we can, meet in a parking lot and, stand around outside with chairs and boards or whatnot, and get documents signed for people or whatever is going to make everybody the most comfortable to get this done. But that's the plan. But I think those are sort of some of the takeaways. And I know we're kind of like right at the tail end here, and I know we have just at least a couple of questions that I noticed that we could probably answer quickly. I know one kind of focuses back on what you were talking about, where someone had asked about, probate process, and whether or not, if they have a simple situation and they each have wills, what's going to happen? Do they still have probate? I think that's
Right. So that's a great question. Yes. So even if your situation is very simple, you're still going to have to go through probate if you have assets that are not controlled by joint title. So if you and your spouse have a residence that's owned as tenancy by the entirety or joint residence with right of survivorship, then the title takes over and controls what happens to those assets at death without needing to go through probate. But if you have a checking account that's just in your own name that has no transfer on death, pay on death, beneficiary designation, then even though it may be small or even though it's a very simple estate as far as the complexity of the assets, you still will likely need to go through probate. There are some exceptions. Jurisdictions have various levels of asset thresholds that may allow you to go through a simplified or modified administration that streamlines the process, but you'll need to check and see what the rules are in your jurisdiction.
great. Thank you. And I think we had a couple of questions as well, kind of about the Secure Act. One of which asked about if someone's already a beneficiary, and I take it by the question that they already have inherited the IRA and have already started taking distributions, which I have to assume happened before the Secure Act came into place. So the Secure Act came up at the beginning of this year and applies to everything going forward. So to the extent that someone's already inherited an IRA and is already taking minimum distributions over their life expectancy, the Secure Act should not change that. This is an issue for anyone who is designating a beneficiary going forward, and those persons who become those beneficiaries and how they have to take their benefits out of the plan. So I think that I've understood that question, but if that's the question, I think that's where you could go on that situation. Is you already have inherited it from a parent or whomever, and you're taking it over your life expectancy. The law is not intended to change that, but you never know sometimes with Congress and what's going on. And I did just want to add, in light of that in Congress, and I know we alluded to the changes that can possibly come up, to remember that, one of the things that we went through at the end of 2012 was there was a lot of back and forth in Congress as to whether an exemption was going to go down to $1 million. It was $5 million at the time. It was going to go down to $1 million at the beginning of 2013. Congress went in on January 2nd of 2013 and said, oh, retroactively, we're going to make the exemption extend. So I think everyone just should be prepared that kind of stuff happens all the time with Congress. Even if there is not a change in the White House and in the Senate to make this a democratic scenario come fall, it doesn't mean this is off the table, because think about the situation that we're in. This is one where a lot of people have lost jobs. So many people are affected in so many ways that the death tax is an easy thing for them to focus on. So, nothing is permanent, no matter how permanent it sounds. But in any event, that's my 2 cents. I don't know if y'all have any 2 cents to add on those or anything else.
And that was great. Thanks, Jane.
And the one thing we just want to mention, Sarah had mentioned in her presentation, just for those of you, that we do have a short PDF about the things you can look at home. So we will be sending that out after the presentation, along with other information too. So if there are any follow-up questions, please do not hesitate to reach out to us. Our contact information is on the slides. Please go I know some people around here are having a Taco Tuesday and hopefully are going to be enjoying that later on. And so maybe all of y'all can go out and have whether a alcoholic, non-alcoholic, Taco Tuesday, whatever you want, happy Cinco de Mayo, and try to maybe help you, like I said, remember what day it is, and we can all go forward. So we want to thank you all so much for coming and attending, and we really appreciate you all being a part of this for us today.